Welcome to This Week in Education Law, where I share up-to-date court decisions from the perspective of educational administrators and policymakers. This is episode 34. In this episode, I'll introduce a recent case about a search of a student's backpack, which resulted in the discovery of a loaded handgun. Did this search violate the student's Fourth Amendment rights, which protect citizens from unreasonable searches and seizures by the government? Let's first look at the background of the case. During the 2018 to 2019 school year, JG was a 14-year-old student at John F. Kennedy High School in Denver, Colorado. He was adjudicated delinquent for unlawful possession of a handgun and felony menacing, which means threatening others with physical harm in a way that could reasonably cause an individual to fear for their safety. In response, his high school, aiming to prevent further incidents while allowing the student to continue his education, conducted a threat assessment and developed an action and intervention plan known as the safety plan. A few months after the plan's initiation, the student was involved in a car theft in which his accomplice carried a gun. After that incident, the safety plan was amended, and by April 2019, the final version of the plan required school personnel to search this student every day when he arrived on campus. The student underwent those searches for the remainder of the school year. After the 2018 to 2019 school year, the student's mother withdrew him from the Kennedy High School and tried to enroll him in a different public school. However, he was placed on the wait list because school enrollment was a requirement for JG's probation. The student went back to the Kennedy High School. This re-enrollment, taking place shortly before the school year began, led to gaps in communication in the school's administration regarding the student's return and the immediate reinstatement of his safety plan. It was unclear whether the school administration was aware that the student had returned to the Kennedy High School. As a result, JG was not searched upon his return to the school for the first 2 days. That oversight was then corrected on the third day when school officials told the student that he needed to comply with the search as he had during the prior school year because the safety plan remained in force. The student refused to cooperate. Campus security officers searched his backpack where they found a loaded handgun. The resource officer placed the student under arrest and he was suspended from the school. The student challenged the legality of this search in juvenile court, arguing that it violated his Fourth Amendment rights due to a lack of reasonable suspicion and his non-consent to the search. The Colorado Supreme Court affirmed the lower court's ruling that the search of the student's backpack under an individualized safety plan was reasonable and did not violate the student's Fourth Amendment. The court's decision emphasizes that searches conducted under a well-documented safety plan designed in response to specific behaviors or threats do not inherently violate a student's Fourth Amendment rights. The Fourth Amendment protects people from unreasonable searches and seizures. In school settings, this constitutional right is interpreted in a unique framework due to schools' need for swift and informal disciplinary procedures. In light of schools' responsibility for students' safety and the need to create and maintain an environment conducive to learning, the usual probable cause level of suspicion is not required. The U.S. Supreme Court allows for a degree of flexibility in how searches are conducted in educational contexts. This flexibility is grounded in the principle of reasonableness, which has two criteria. The search must be reasonable at its inception, and the search must be appropriately limited in its scope. Thus, the school's search of the student's backpack meet the first criterion of being reasonable at its inception. The student argued that he didn't do anything on that particular day that gave rise to the reasonable suspicion justifying a search. The school resource officer testified that the search was carried out in compliance with the safety plan, not based on the student's action on that day. The court noted that the reasonableness at inception includes the totality of the circumstance that prompted the search. Generally, students do have a legitimate expectation of privacy in the personal items they bring to school. But most students are not subjected to a safety plan that requires daily searches. That daily search requirement necessarily diminishes the legitimate privacy expectations. In this case, the search of the student's backpack was predicated on a well-documented safety plan developed in response to the student's previous behavior, specifically his involvement with firearms. This plan was a structured response to a clear and documented risk, making the decision to search the student's backpack grounded in a legitimate concern for the safety of the school community. The second criteria of reasonableness is not at issue in this case. Regarding the scope of search, the student was not subjected to an unnecessarily invasive search because the concern was the student's possession of weapons and handguns, specifically his backpack, was a reasonable place to search. And the removal and opening of his backpack was not more intrusive than expected. The student further argued that he was not notified about the continuation of his safety plan into the new school year. The court reasoned that while explicit notice of the safety plan's continuation is beneficial, the essence of its constitutionality does not hinge solely on this notice. Instead, what matters is whether the student had a reasonable understanding that the plan was still effective, thereby adjusting their expectation of privacy accordingly. What can educational administrators learn from this case? Although the court ruled in favor of the school administrators could do a better job to prevent similar cases. First, the confusion surrounding the student's return and the enforcement of his safety plan highlights the need for clear, consistent communication channels in the school's administration. Who is responsible for monitoring the presence and status of students under safety plans? How can your school ensure that all relevant staff are promptly informed when a student under a safety plan returns to school? Does your school have clear procedures to ensure accurate, up-to-date records regarding students' safety plans and ensure they are accessible to all relevant parties? How does your school manage documentation related to safety plans, and how can those records be made more accessible to key personnel? Second, the absence of a re-entry meeting for the student at the beginning of the school year was a missed opportunity to reaffirm the safety plan's status and requirements. Does your school have a structured re-entry process for students returning under specific conditions or after significant absences? How can this process be reinforced to prevent oversight? And the third, interaction between the student's mother and the dean of students, where there was a suggestion from the dean of the student that the student may no longer need a safety plan, suggests that the potential for miscommunication. Did the dean of students make that suggestion? In this case, the dean of the students did not testify in court. If yes, the dean of students should have examined the policy documentation or guidelines that might have justified that statement. Ideally, the school should have a clear documented procedures for evaluating and updating safety plans, which includes criteria for determining when a plan may no longer be necessary. This documentation should outline the process for evaluating a student's behavior, progress, and risk factors over time, involving input from different team members that may include educators, school counselors, and possibly law enforcement or mental health professionals. Upon suggesting the potential discontinuation of a safety plan, the Dean of Students should have referred to specific parts of this policy documentation that were applicable to the student's situation. For example, the policy may include benchmarks for behavior improvement, risk assessment outcomes, or other indicators that suggest a student no longer poses the same level of risk to themselves or others. Without this evidence, it's very difficult to justify the statement that the student may not need the safety plan anymore. Following this procedure, any communication about the possibility of ending the safety plan should have been formally documented, including the rationale behind the suggestion, the criteria used for assessment, and the outcomes of any review meetings. This documentation would then be shared with the student's mother, ensuring that she had a clear understanding of the process and the evidence supporting the dean's statement. It's important for school administrators to base their communication on established policies and documented procedures. Making statements without policy justification can lead to misunderstandings, miscommunications, and potentially legal challenges. It's important for administrators to ensure that their action and communications are always supported by a clear, documented rationale that aligns with the school's procedures and guidelines. This approach not only maintains transparency and trust, but also upholds the integrity and accountability of the educational institution's decision-making processes.